Thank you so much for joining for today's webinar, looking at tariffs after the Supreme Court and what digital health needs to know. We are grateful to have Milton Koch back with us again for another webinar on the impact of trade policy on digital health. Milton is an international trade advisor with Buchanan, Ingersoll, and Rooney, where he provides analysis to domestic producers in trade remedy litigation, with a particular emphasis on anti-dumping investigations before the Department of Commerce. Milton has joined us for a number of webinars, both when these policies were initially initiated by the Trump administration, as well as when new updates came out later in the year regarding some regulations affecting medical devices. We're grateful to have you back again to talk about this important issue, and I'll turn it over to you.
All right. Thank you so much, Lydia, and thank you, CTeL, for having me here today. It's great to always be presenting to the telehealth community. So I have up here the agenda of what I'm going to cover today. I'm going to start with the Supreme Court decision. I'll talk about less about the Supreme Court decision and more about what's going to happen next as a result of the reciprocal tariffs going away. And then we'll kind of dive into some areas that I think will actually going to affect the telehealth industry specifically, whether it be a tariff investigation on medical equipment or some other actions that are being taken by the Trump administration that I think are a little bit under the radar right now. So with that, yeah, let's go ahead and get started. So the Supreme Court had a decision. It was Learning Resources, Inc. versus Trump. And on February 20th, they decided that the International Economic Emergencies Power Act does not, in fact, give the Trump administration the ability to create tariffs. And this really hinged on the definition of the word regulate. One key piece of this that kind of was out there is when Congress was contemplating and did create the International Economic Powers Act, they were replacing the Trading with the Enemies Act. And when they did that, they intentionally took out some of the language that had to do with tariffs that was in the Trading with the Enemies Act. So as you can see, the Supreme Court found that in Learning Resources that the power to regulate does not include the ability to impose tariffs. And so that means the reciprocal tariffs are unconstitutional. They did leave refunds as an open question that they didn't touch on. They remanded that down to the Court of International Trade to take a look at and decide what should be done. But the result was the White House immediately put out a series of executive orders and press releases. Some of them are straightforward, right? They said, we are going to be ending the reciprocal tariffs. Others are, we're going to be continuing the de minimis treatments, suspending that for all countries. They are able to still do that, even with the Supreme Court ruling. Others were a little bit more interesting. They have decided that they would start a series of new trade investigations, the first one of which is Section 122. And this was announced in a bunch of Truth Social posts, and you can see here some of the commentary by President Trump about the Supreme Court decision itself, but then saying that also we're going to replace the reciprocal tariffs with a Section 122 investigation that will result in a 10% worldwide tariff. So what is Section 122? Well, that comes out of the Trade Act of 1974. And President Trump has said, we're going to use this to replace the IEEPA tariffs temporarily. Initially, he said it's going to be 10%. There's been some talk that it will be increased to 15%, including today. Secretary Bessent said it would increase to 15% perhaps as soon as next week. It's a temporary measure, right? Section 122 only allows the U.S. president to impose tariffs of up to 15% for 150 days. And this is designed to be done to work as an emergency basis to address financial instability. So there's no need for an investigation, which is why they're looking to use this. Now, as we saw with those Truth Social posts, there's going to be a series of investigations on the way. And so as a result, it's not expected that President Trump will ask for Congress at the end of the 150-day period if he can renew Section 122 or not. Now, again, 10 to 15% still up in the air. That 15%, they're doing this to try and mirror and replace the reciprocal tariffs. And so there's a lot of this that's the same. For example, all of the exemptions that were in place with the reciprocal tariffs, those are going to be in place here too. And one of those exemptions that I'd kind of highlight is if it's not produced in the US or if it's covered by a Section 232 trade investigation. We'll touch on those in a bit. Then the 15, 10, or 15% Section 122 tariff does not apply. Now, there are a few pieces of this that don't exactly line up. There are some tensions with all the countries that signed trade agreements with the US to get a lower reciprocal tariff rate in terms of how this all is going to work. Now, again, Section 122, that's only going to last for 5 months, 150 days. As the second part of this to replace the reciprocal tariffs, the US Trade Representative, Jamieson Greer, has announced that they're going to be launching a series of Section 301 investigations. And they've made clear that they're going to do this on an accelerated basis with the goal of getting this done within the 5 month period that is covered by the Section 122 tariffs. Now, Section 301 is relatively permanent. In the first Trump administration, there was Section 301 investigation and tariffs applied to China for intellectual property theft. President Biden renewed those tariffs for another 4 years, and he actually expanded them to cover many items, many medical devices, and PPE. And I have up here the chart, and you can see that even as a result of Biden's decision about 18 months to 2 years ago, several of these are still coming into play now, where tariffs are jumping up 50 to 100%, whether it be for syringes, gloves, masks, things of that nature. So this is showing that, something that started in 2017 is still going strong about 8 years later. It's more or less permanent, and that's what they're looking to replace the reciprocal tariffs for. So whether it's IEEPA, which is what it was before, Section 122 is what it is right now, and then Section 301 is where we're going in the next 5 months. At the same time that they're doing that, those are all actions that have seemed to be designed to be country-specific tariffs. And the Trump administration has been pretty clear that while they're implementing these tariffs on a countrywide basis, they are also at the same time creating exemptions and saying, well, these are the tariffs that apply unless a Section 232 national security investigation tariff applies instead. Now, what are Section 232s? The big difference there is that it's not going to be countrywide. It's actually product specific, and it's done on an industry sectoral basis. There's been roughly a dozen Section 232 investigations announced over the last year, covering a wide range of products. I think steel and aluminum is the one that's gotten the most attention, but there's others covering wood and other products like that. The two that I think are ongoing right now that really apply to the telemedicine industry are medical devices and pharmaceuticals. I do have up here also the list of other Section 232 and what industries they would cover that are being considered right now. Again, they have yet to actually announce any of those investigations yet. But let's go more in depth in medical devices, because I think that's the one that actually is going to matter the most for the telemedicine industry. So the notice was published back in September. It was announced September 26th, starting in September 2nd. They got 270 days for Commerce to basically create a report for the president with recommendations for action. Those recommendations are expected to come out as late as May 2026, may come a little sooner, but at the latest would be in May. From there, President Trump would have 90 days to decide which of Commerce's recommendations he wants to keep and implement and which ones he does not want to implement. Now, that puts it lining up pretty dang tight with the 5 months for the Section 122, which would be July 2026 for when those 10% tariffs would end. So I think between that May to July period is when we're actually going to start seeing a bunch of announcements at the beginning of the summer, more tariffs, not just for medical devices, but for other investigations as well, whether it be done with Section 232, Section 301, or otherwise. Now, other Section 232 investigations, they typically do result in a 25% tariff. The exemption to that has been steel and aluminum, which is currently at 50% right now. So how are they defining medical devices? I've got the definition up here on the board. Most of these do not apply to telehealth, but I would draw your attention to the portion that I highlighted in yellow here. Instrument, apparatus, or machine used in the diagnosis, monitoring, treatment of medical conditions. That sure sounds like it could cover telehealth. The examples they give up here of things like X-ray, MRI machines, and other things like blood glucose monitors. Those don't necessarily mean telemedicine, but they might be a part of it. So the comment period has ended. That was back in, I believe, October for the Section 232 on medical devices. But you can see here the criteria that they were looking at. I've got it up on this slide here and on this one as well. And it kind of boils down to two key aspects. One is they're concerned about supply chain reliability. And then two, what is the ability for the domestic industry to meet an increase in demand? Do they have the capacity to meet and to produce it in the US? Or is this something that would cause more problems than it would be worth? And I think that right there, based on those comments that are going to be submitted, again, it's product specific. That's going to allow them to kind of tweak and customize the tariffs and decide which products should be covered by which tariff rates and which ones should be excluded because the US may not have any production right now or less production. Now, what else can we expect when the investigation is complete? One is there have been negotiations, right? Automobiles stood for 25% tariffs for everyone, except Japan and the EU were able to negotiate that down to 15%. The tariffs, again, they're product specific. They don't cover specific countries. They cover all imports of that product. One other piece that I think is interesting is there's been, in the first Trump administration, there was an ability to request exclusions from the tariffs. Now they've flipped that process on its head, and instead you can ask for more products to be added. So the result is every 4 to 6 months or so, you can request new products be added. They'll decide to include them. When they do, that results in a whole new series of products being covered by the tariffs, whether it be 25% or otherwise. The other piece that's on the horizon and kind of lines up with that July timeframe is the USMCA NAFTA 2.0 is up for renewal July 1. Right now, they have included language both in Section 122 and in some of the Section 232s as well, saying that USMCA compliant goods are exempt from all of these tariffs. It can be a little bit murky at times as it depends what portion of the products, of the raw materials going in to build the device, may or may not allow it to qualify. That's why I say it's not 100% perfect. But in general, if you are sourcing products from Mexico or Canada, chances are you would be exempt from a lot of these tariffs. So what's the impact going to be? Well, there's potential shortages, right? The US already has a supply chain that's strained. There's definitely plenty of disruptions going on right now. And we do rely on imports for a good amount of our medical products and healthcare devices. But that's just the direct impact. I would highlight that there's also going to be a bunch of indirect impacts as well. It's going to be more expensive to build a hospital. That's going to increase the cost for healthcare across the board. It's going to increase the cost if we got to manufacture everything at home. And quite frankly, if you have to pay the tariffs, whether it be for raw material parts or the finished goods themselves, it's going to be more expensive. The other part of this is as the telehealth community really has to get on top of their compliance costs. I think before it mattered to some degree whether you knew your supply chain as well as you did, but in general, you would be fine if you did not. I don't think that exists as much. We're not in that world anymore. You need to be aware of what your supply chain is. And in particular, you need to know who is the importer of record and who has the liability for paying any of these tariffs. Just as an example, if the tariffs go up a lot for medical devices, it may lead several companies to decide to basically exit the US market. In that case, you need to know what are alternative sources of supply to be able to adjust your supply chain as necessary. So other actions that are affecting the telehealth industry. One, the Supreme Court did not rule on what would happen with IEEPA refunds. That's going to be ongoing litigation at the Court of International Trade. If you are interested in pursuing a refund on any of the IEEPA tariffs you may have already paid, please contact me afterward and we can discuss that offline. But two, we've also shifted gears in that the Trump administration has put a lot of these different tariffs in place, and now they're really going forward and enforcing it wholesale. And so they've created a DOJ trade fraud task force that is set up to mimic what was done with the healthcare fraud task force. And part of that includes that now they're using the False Claims Act to go after people who are not paying their tariffs. There's also been 2 new investigations announced last week after the Supreme Court decision at the International Trade Commission. These are fact-finding investigations, but they generally are geared as a first step towards other types of investigations or laws or tariffs being implemented. So one of them has to do with whether it makes sense to revoke normal trade relations with China. I think I'll leave that one be. It's being done on an accelerated basis. People are willing to, you are able to submit comments if you are interested, but there will not be any hearing. It's not clear whether the report will be public as much or not. And then you also have separately a fact-finding investigation into the pricing practices of China and its state support for the biotech sector, and how is that impacting the US health sector and biotechnology specifically. I don't think that's directly impacting telehealth and telemedicine, but I do bring it up because in addition to the pharmaceuticals and these other investigations we're seeing, this is another one that may have an indirect impact if it leads to other restrictions on either data or what's allowed to be imported or what can be sourced, what can be used from different countries. For example, there may be a requirement for more clinical testing to be done in the US as a result of the ITC's report. So then the big thing that also has happened is back in the fall, the DOJ's data security program became effective, and the grace period for that has basically ended. So DOJ is now going to be enforcing this, and this is something that I think will actually directly impact a lot of telehealth providers. It's broader than HIPAA. It's not just personal identifiable information, it's any sensitive personal data. Just because you have it encrypted or de-identified it does not exempt you from the requirements from DOJ. It does restrict any transactions that happen with countries of concern, which is China, Russia, Venezuela, Cuba, Iran, so on and so forth. I have up here the bulk data thresholds, and I think you can see that a lot of these are actually relatively low. Personal health data of 10,000 individuals is not that high, all things considered. But also, there's no exemptions whatsoever if you have any data that relates to US government employees or contractors. I would note that that would be any program that involves the US military in particular, and possibly the Veterans Administration. So how does this bulk data thing work? Well, you're prohibited from a lot of transactions. You can't do anything that involves data brokerage with any of those countries I talked about a minute ago. You can involve in restricted transactions if you can prove that you've done your compliance work to show how you've done an audit, how you have protected, you've got good cybersecurity, and you are keeping the data safe. And there's no risk of the data being spilled or shared out into the public by sharing it with other parties. There are a few areas that are exempt, and I have them listed up here. I would say focus on the last three. These in particular show that there are some exemptions that make sense, like if you're seeking regulatory approval in Europe, you would be exempt from this data security program. But other things that, again, are very broad, it doesn't have to just be HIPAA. If it's anything relating to personal sensitive data, you may fall afoul of this program, and this is something that I think they are going to be starting to enforce more in the future. So that's all I have for today's presentation, but I welcome any questions anyone has. All right. Well, with that, Lydia, back to you.
Great. Thank you so much. I think one of the big questions that we've gotten about that last piece, the bulk data thing, is how that affects AI, and how the data being transferred to either train or otherwise create health AI models may be implicated in this DOJ rule. Have we seen any developments or any indication that that might be implicated here?
Yeah, so I think AI is in fact covered by this program, and in general, there seems to be a growing trend of more export controls and more sensitivity around not just life sciences, but also AI in general. So this is definitely an area that would be of concern. In general, a lot of this does overlap, though, right? If you have good cybersecurity policies, chances are you are being audited already, and you may be able to qualify for that exemption, sorry, not exemption, for the restricted transactions. I think it depends again on making sure that your data is secure and that you're able to track and trace it in a lot of ways.
And also perhaps with on a similar note related to AI with the Department of Defense declaring Anthropic and its
Yes.
models to be supply chain risks. Do you see any sort of entanglement with some of these trade laws or any possible risks to
Hmm.
those who are
Sure.
using Anthropic models?
Yeah, absolutely. So, and I think that's a great point. There is a fair amount of overlap between the world of international trade and national security. A lot of this is collapsing. Whereas I think before you could generally say, hey, this is just business. This doesn't have to do with the military or national security. That's not necessarily the case anymore. And I think Anthropic and the DoD and what happened last week is just an example of that trend continuing. The designation that Anthropic is a supply chain risk means that many parties are not able to work with Anthropic if they want to work with the US government or US military as well. Just as an extreme example, Amazon and Microsoft, Azure, all of those services do work with the US government based on the policies they've signed on to create secure supply chains for the US government. They may or may not be able to work with Anthropic as much or possibly at all in an extreme example.
We have a question in the chat asking, could you speak to the possibility of the refunds and if there could be price impacts or requirements for consumer refunds if they come through? And would this be a consideration going forward on future tariff applications?
Sure. So to date, there have not has not been much consideration given to how refunds would be done. So I think for these new future tariff applications, that's not necessarily going to be something that they're considering. That being said, you are definitely seeing the Trump administration being more and more concerned about affordability and trying to be a little bit more careful in how they scope the tariffs to ensure that they don't needlessly create inflation or cause hardship. Now, in terms of the possibility of refunds, I think it's one of those things where it's going to be hard to tell as the litigation is just getting started now. I think the refunds are very likely to occur, but and the Court of International Trade is ruling on that, I think, as quick as they can. But they just were told last week that they can begin considering it. Is that going to result in consumer refunds? I don't think so, unless Congress passes a law just saying we're going to refund it. It is refunded, it will be provided to the consumer. I think it's more likely that the refunds will go to the people who paid the tariffs originally. That would be the importer of record. So, as an example, if the telehealth industry, if you are a company that is not importing directly, you do not have to pay the tariff, so you also would not get the refund. As the customer, I'm not sure that you would necessarily get a refund for past actions, but it's quite possible that you would see your suppliers competing on price more, and they would then lower their prices going forward.
Any other questions?
Great. Okay. Well, thank you all for having me here today. It was a pleasure presenting to all of you. If you have any questions, please don't hesitate to reach out to me afterwards. Happy to always talk about international trade tariffs and everything else that's going on with the DOJ bulk data program too.
Great. Thank you so much. We appreciate you sharing your expertise with us. And I hope you all have a great rest of your day.
Thank you.